Hi, my name is Intan Nulana. I am from Group 3. Today my group is going to discuss comparisons and cases related to clauses 46 until 70 from Form of Contract PWD203A. We are going to make a comparison between the Form of Contract PAM 2018 and CIDB 2000 with PWD203A. For the first 8 clauses, Muhammad Akil Irfan is going to talk about it.
Hello and Assalamualaikum. My name is Akil and today I'll be talking about the topics that I'll be comparing according to PWD forms, PAM contracts and CIDB. So one of the topics I'll be talking about is access for works. According to PWD form, clause 46, which is access for works. According to PAM contract, it is clause 9, access to works. And according to CIDB, it is clause 17.4, rights of way or access. So here's the comparison. All three forms recognize the importance of site access for monitoring, progress and supervision. For instance, PWD Form 203A places strong emphasis on the right of the government or SO, superintending officer, to access the site for quality assurance and compliance. PAM 2006 focuses on the mutual understanding that while the contractor controls access, the employer and consultant must still be allowed on site to fulfill their roles, provided their presence does not hinder construction progress. CIDB 2000 presents the most detailed structure by clearly splitting responsibilities. So, the case that is related to this topic is Sanisa Sdn Bhd versus Kerajaan Malaysia and ANOR. In this case of Sanisa Sdn Bhd versus Kerajaan Malaysia and ANOR 2020, the contractor, Sanisa, delays in project completion due to government's failure to provide timely site access. Sanisa claimed for loss and expense under clause 44.1 of PWD. However, High Court dismissed the claim, emphasizing that Sanisa had not submitted the request written notice within the stipulated 30 days period following the delay event. This decision underscored the critical importance of adhering to contractual notice requirement when seeking remedies for access-related delays. So, for the next topic, it is about subcontract or assignment. Based on PWD, it is clause 47, PAM contract clause 17, and CIDB clause 40. All three contracts prohibits full assignment or subcontracting without consent, and none allow full delegation of works. PWD and PAM allow typical subcontracting for specialist works without excessive formalities. CIDB is more procedural and detailed, offering structured and expectations and addition documentation requirements. In every form, the contract maintains full responsibility for quality, compliance and delivery. So, the case that is related to this topic is Holis Metal Industries Sdn Bhd versus YTL Construction Sdn Bhd 2005. The facts are, YTL Construction Sdn Bhd was the main contractor for a project. Holis Metal Industries Sdn Bhd was appointed as a subcontractor to carry out specific works under YTL. A dispute arose when Holis Metal alleged that it had not been paid for the work it completed. Instead of suing YTL, Holis attempted to claim payment directly from the employer, bypassing YTL. The legal issue here is whether a collateral contract existed between Holis and the employer. And the decision is, the court held that there was no privity of contract between Holis Metal and the employer. Holis Metal could not enforce payment or make any legal claims against the employer directly, since there was no collateral contract or special agreement between Holis and the employer. Holis had no legal rights to sue the employer. The next topic is defect after completion. PWD Clause 48, defect after completion. PAM contract clause 15, practical completion and defect liability, and CIDB clause 27, defect liability after completion. All three standard form establish clear post-completion obligation for rectifying defects during the DLP, while PWD and PAM place emphasis on written notice and retention based on enforcement. CIDB offers a more detailed breakdown, including cost recovery, search obligations, and remedies for irreparable defects. The suitable case for this topic is P&M Kaye versus Heuser and Dixon, 1972. The facts are P&M Kaye, the employer, entered into a building contract with Heuser and Dixon, the contractor. After practical completion, several defects appeared in the works. The contract included a defect liability clause that gave the contractor the right to return the site and remedy the defect within a set period. Instead of allowing the contractor to fix the defects, the employer engaged another contractor to do the work and sued the original contractor for the cost. However, the original contractor argued that they were not given the chance to fix the defects. So the issue here is, does an employer have the right to recover rectification costs from the contractor without first giving the contractor the opportunity to fix the defects? The decision here is the court ruled in favor of the contractor. It held that where a contract includes a defect liability clause, the employer must first allow the original contractor the opportunity to make goods and defects. Next is unfulfilled obligation. PWD Clause 49, PAM Contract Clause 6.4, CIDB Clause 7.1. All three forms reinforce the principle that contractual responsibility does not end at physical completion. PWD explicitly addresses post-completion obligation such as warranties and documentations. PAM ensures continued liability even in the event of delegation, while CIDB underscores ongoing responsibility through the lens of quality, compliance, and comprehensive execution. The case that is related to this topic is Syarikat Pembinaan Perlis Sdn Bhd versus Sri Kinabalu Sdn Bhd 1991. The facts are Syarikat Pembinaan Perlis Sdn Bhd, the plaintiff, entered into a construction contract with Sri Kinabalu, the defendant, to carry out a building work. The plaintiff was responsible for contracting a building project according to the specification, drawing, and timeline stated in the contract. However, over the course of project, the contractor consistently delayed progress of work. There were numerous defects in the completed portion of the project. The contractor ignored instructions. The overall performance was unsatisfactory, failing to meet the standards required. So, the defendant eventually terminated the contract. The legal issue here is whether the plaintiff had breaches fundamental obligations under the contract, whether the defendant was justified in terminating the contract, whether the plaintiff was entitled to any outstanding payment, or whether the defendant could recover damages. However, the High Court ruled in favor of the defendant. The court found that the plaintiff failed to complete the works in accordance with the contract and had breached several essential terms. The court held that the failure was not trivial. It went to the roof of the contract, making it impossible for the defendant to continue relying on the plaintiff to finish the project properly. Therefore, the termination was valid. Next is suspension of works. PWD Clause 50, PAM Contract Clause 21.4, CIDB Clause 19.1. PWD and CIDB outlines specific timeline for submitting claims, while PAM includes a provision for possible contract termination after prolonged suspension. So, the case that is related to this topic is Pernas Construction versus Syarikat Rasa Bina 2004. The facts are Pernas Construction, the main contractor, engaged Syarikat Rasa Bina, the subcontractor, to carry out piling works. There were delays in commencing and continuation of work due to suspension instruction issued by the main contractor. Eventually, the subcontractor terminated the subcontract, claiming that the prolonged suspension amounted to a repudiatory breach. The main contractor disputed this and counterclaimed for breach of contract. So the issue here is whether the suspension of work by the main contractor justified the subcontractor's termination of contract. The decision here is the court ruled in favor of the subcontractor. The court emphasizes the importance of clear instruction, reasonable suspension periods, and the contractor's right to protect itself from indefinite delays and losses. So next is about events and consequences by default by the contractor. PWD form, clause 51, PAM contract, clause 25.1, CIDB, clause 44.1. PWD and CIDB allows the employer to take possession of the site and complete the works upon termination. PAM emphasizes procedural fairness with a remedy period before termination is executed. CIDB is the most outlined and detailed termination procedures, while PWD is more direct and practical. The case that is relevant to this topic is Sia Fiatun versus Lim Sui Hui, 1965. The facts are, during the performance of the contract, the contractor failed to perform properly and in accordance with the specification. There was delay and non-compliance with the instruction given by the employer. The employer ultimately terminated the contract. The original contractor sued the wrongful termination and claimed for the balance of the contract sum. The issue here is whether the employer was justified in terminating the contract due to contractor's default, and the decision by the court is in favor of the employer. It held the contractor's persistent failure to comply with the instruction and failure to carry out the work properly constitute a fundamental breach.